Okay, I think we're going to get started. Thank you, everyone, for being here today. I am very excited to introduce Esther Lim of Her Justice. Her Justice are amazing advocates for women in New York City in a variety of contexts, including immigration, where they are experts in a particularly trying time for immigration lawyers. We're really lucky to have these amazing advocates working with us, training us, and doing some good. We're taping today's we're taping today's training. There are also CLE credits for today's training, so attorneys can sign up in the sign-up sheets, which are somewhere floating around the room. And without further ado, here's Esther.
Hang on real quick. I'm sorry. Hi, everybody. I'm so sorry. My name is Esther. I want to say thank you to Akin Gump for hosting us again. You guys host us every year for our VAWA training for the Summer Associate Program. So again, thank you so much for having us. And we're very, very happy to be here. Again, this is Her Justice's VAWA self-petition and hardship waivers training. So if you are not supposed to be here because you're supposed to be somewhere else, it's okay to leave. But otherwise, you can stay and enjoy me talking at you for about 2.5 hours. There's a lot of material to cover there. You will see the agenda. There is about a 10-minute break in the middle of it. I will be keeping track of time to kind of figure out where we can speed things up, slow things down. Throughout the training, please feel free to just raise your hand and ask questions as they come up. There is a short period for Q&A at the end as well. I'm thinking that most of you have received your case file, so if you have been able to peruse that, maybe sometime during the training, if you do have questions about your specific case, you can ask those questions as well, okay? It is mainly Akin here, but there are folks from other firms. So everybody, like confidentiality reasons, do not talk about your client's first name, last name, or anything like that. Just say like whatever the question is, okay? And without further ado, I'm going to show a short video about Her Justice and what we do.
As a lawyer and a New Yorker, I am proud to live in a city that takes care of its own. At Her Justice, we provide legal services to low-income women in crisis in the areas of family, matrimonial, and immigration law. Last year, Her Justice provided legal services to over 3,000 women and their over 4,000 children. Our clients are incredibly strong, and many of them have survived great hardship. What they don't have is access. Her Justice makes sure that our clients receive that access by connecting them with private attorneys from around the city so that our clients have access to the legal tools that give them safety, security, and self-sufficiency.
We used to fight a lot, and he used to abuse me physically to a point that in more than one occasion I thought to end my life because there was no other way out.
He wanted my pension, 401k, medical benefits. He wanted my furniture at one time. It seemed like he was winning all along, you know?
My client was arrested because her abuser had actually called the New York Police Department and alleged that our client was harassing him.
My marriage was built on deceit, and it escalated from verbal abuse to physical.
Quería romper un ciclo que no era beneficioso para mí ni para mis hijos. Tú vas a salir de casa y mi hijo se va a quedar en casa.
Court itself, it is not being operated in a way that is helpful to the very people that it was set up to serve.
While our clients may have compelling stories, it doesn't necessarily mean that their entire stories can be heard without a lawyer stepping in.
When people go to courts and they don't have a lawyer, they come up short, even when the law's been designed to protect them.
When we have 12 attorneys on staff, who can then leverage the legal support from the private bar, we are able to represent and help over 7,000 people every year.
Because of the law firms that donate their services to us, and because of our people that within our walls are able to train them, help and represent our clients, that is how we are able to best serve the community.
The work of Her Justice is vital to women who are not in a very empowered status. It can be very difficult for them to assert the rights that they do have. Her Justice empowers these women to understand that they do have rights.
Many of our clients are completely in the dark about the financial circumstances of their marriage. We know that our pro bono attorneys can make the biggest difference in the lives of those clients by partnering often with financial accounting firms to investigate the income of the spouse and get the client a fair financial award.
We'll look for hidden facts such as if a defendant's hiding income, hiding employment, hiding assets, and we use our investigative experience to get the information that's most helpful to Her Justice and the pro bono attorneys.
Providing pro bono services means that I get to see those results on someone's face when they get an order of support or an order of protection to get them the financial means that they need to help raise their child or to get them safety away from someone who's putting them in danger.
We know we have these incredible mentors, brilliant, talented, resourceful, responsive attorneys who sort of have our back on every matter.
In my experience working with the attorneys at Her Justice, I have been so impressed by their dedication and commitment and the quality of service that they've provided to their clients. I actually grew up in foster care in New York, and as a child, I never had access to the quality of professional and legal services that Her Justice provides.
I think her life is unimaginably different because she came in contact with Her Justice. She might have been deported by now. Instead, she has status and she's living with her daughter here.
If I didn't have Her Justice there to help me with the case, I would still be married to the man who raped me and tortured me.
The fact that Alice's husband was sentenced to 40 years in prison really speaks to the brutality of what Alice endured. Without Her Justice, Alice would have had to face her abuser in trial alone.
Judge ordered that he does not get any part of my retirement or 401k or any medical or furniture or whatever he wanted. He's getting nothing.
I was an illegal immigrant. I have a work permit now. The fact that I had a social security number and I was able to have a bank account to deposit my check. It was like I'm normal.
I don't think I'll be who I am today. Confident, relaxed, secure, happy. Without Her Justice, my life would be totally different.
As a lifelong New Yorker, I'm proud to be part of the Her Justice community, where we shift the power to the low-income women who call us every day, who are seeking to build safer and more secure lives for themselves and their children.
Ha sido difícil los cambios, pero lo importante que tenemos es la tranquilidad y estamos saliendo adelante gracias a esta agencia, Her Justice.
I want to thank Her Justice for the amazing team that inspires you to put your best foot forward.
I want to thank Her Justice for giving me my life back.
Give her opportunity.
Horia. Dignity.
Shivang.
Give her courage.
For security.
Access.
Compassion.
Un mejor futuro.
A new beginning.
Give her justice.
So that is a brief overview of some of the clients and the attorneys that we work with. And you here in this room are going to be part of those ranks now as pro bono attorneys working on a case for Her Justice. If you look, this is our mission. We were founded in 1993, and we are here to mentor volunteer lawyers to provide free legal help for low-income women in New York City. So, who exactly we have a pro bono first model. So we have 13 Her Justice attorneys, and we mentor about 1,800 legal volunteers. Again, they are not all lawyers. Some of them, as you saw, are from financial institutions and other types of institutions. So we do mentor a good number of other professionals. It's about 1,800 of them. And we serve about over 9,000 women and children. And it totals up to $41 million of pro bono hours. And so why we do this? Because low-income women in crisis need vital legal protections, safety, financial security, and immigration status. And who are our clients? Our clients come from all 5 boroughs of New York City, mainly from Queens, Bronx, and Brooklyn, but we do service all five boroughs of the city. And we're going to talk a little bit about intimate partner violence because at this point, it's kind of weird. I'm going to skip over this for a minute because it's not supposed to be there. Anyways, best practices in terms of communicating with your client. You want to be open and engaging and warm. You want to welcome your clients to your office. This may be the first time they do step into an office like this in this city. So you do want to help them to feel at home and not intimidated. You do actually, and definitely need to manage deadlines. There are some of your cases today, they will have hard deadlines. I don't think there's any that are during the summer, but please be aware of certain deadlines that are in your cases. And obviously, you're going to be working with your Her Justice mentor. I am the mentor for Akin Gump. I know that there are some attorneys from Cravath, yes? Okay, Cravath is another attorney, Susanna Saul, she's going to be your mentor. And somewhere else, no? Just Cravath? Okay. And reaching your mentor, you're going to first read the manual, then you're going to leave a voicemail on our direct lines. You can email us, you can schedule phone calls. Each mentor deals with it differently in terms of communicating with you throughout the summer or throughout the case. So for me, it's usually shoot me an email, tell me that you want to talk, or you shoot me an email with some questions. And if I don't respond back like almost immediately or within a day, shoot me another email, nudge me again, call me, what have you, and I will get back to you. Okay. Today's learning objectives for today's training is advise your clients and explain the VAWA self-petition process. VAWA stands for Violence Against Women Act self-petition process, which is the process in which somebody will petition for themselves for their green card. I'll explain more of that in a minute. You're going to interview your client and supporting affiants. You're going to identify and collect relevant evidence. You'll draft affidavits addressing the required elements, and you will submit everything to the United States Citizenship and Immigration Service, USCIS. So our training and our summer associate program is geared towards you being able to finish this within the 10 weeks that you are here at Akin or here at Cravath or whatever your summer program is. So we do try to give you a definite timeline so you can finish it, so your supervising attorneys aren't stuck with these cases after you guys leave. However, we know that things come up and it does tend to take longer than that many times, but again, it is kind of geared towards with that idea that you will be able to finish and actually file this at the end. Okay, so now we're going into the Domestic Violence 101. Why do we do the Domestic Violence 101 in this training? Is because every single one of your clients will have been or are survivors or of domestic violence. Okay, so they have been battered or abused in some way or another, and that is why they are able to do a battered spouse waiver or a VAWA self-petition. So what is domestic violence? It is a pattern of coercive and abusive behavior used in any relationship to gain or maintain power and control over another. So basically, it is about the power and control. It could be one incident of physical violence or no incidents of physical violence. It could be just intimidation, emotional abuse, economic abuse, social isolation. Things like this are all considered domestic violence, but it has to be a pattern. So say that it's a one-off situation. Somebody gets hurt, like somebody gets hit, and would you say that's domestic violence? Depends. What do you guys think? Would that be domestic violence? Somebody gets hit once, like gets beaten up really badly. Would you say it's domestic violence? Yes, it can be, right? If you think about it, because after that one incident, then what happens? He doesn't hit her again, but then he uses that one incident and says, remember what I did to you, right? Remember what could happen. Do you want that to happen again? And he uses that again and again and again. I had a client who said he basically told her, I'm going to cut you up into pieces and send you back to your home country. And then he brought a huge duffel bag into the room and left it in the corner. And that's all he did. He didn't do anything else. He just left it in the corner, and anytime he got angry with her, he would just point to that duffel bag and say, remember what I said, and that was it. And that was his form of controlling her. He scared her to think that he was going to cut her up into pieces, put her into this big duffel bag, and ship her back to her home country. So it doesn't have to be this, like always pushing, shoving, kicking, like what you see in the movies, it can be, a lot of it is going to be psychological. A lot of your clients will have suffered more psychological and emotional abuse than that physical abuse. Okay. So what kinds of effects of the domestic violence does it have on your clients? Health effects, physical, sexual, mental, dependency, shelter, economic, and substance abuse, cultural, religious effects. Like people say, oh, you know what, I can't go back to my home country, I can't go back into my community because I'm shamed, things like this. So you want to bring all of this into the narrative of your client when she's talking about that domestic violence, because what you want to do is educate those folks up at Vermont Service Center who are actually going to be adjudicating these applications to know that, yes, my client, this does mean it was domestic violence because she did this happened to her. These are the effects that happened because of her, of what he did to her. They're becoming very, very strict in their ideas of what domestic violence is, what a good faith marriage is, and we'll go through some of these elements in a bit. But basically, this administration has become not so nice about the way they're adjudicating. They don't give a lot of leeway. You have to really spell everything out for them and lay it out for them so that they can actually connect those dots and say, okay, this is, you can't just leave a little trails of breadcrumbs anymore. You really have to paint that big picture for them. So when you're working with your domestic violence survivors, what do you have to be mindful of? The trauma has a powerful impact. Be patient and non-judgmental. Many times your clients may come in and have absolutely no affect at all because they have been abused and they have been in such a place where they're emotionally not able to even process this anymore. So they might come in and you're talking to them and they're like, I'm fine. I'm out of this situation, I'm fine. Why do you want me to talk about all of this stuff that has happened? Because now I'm over it. But you want to try to draw that out from them and say, we know you're fine, we know you're moving on. These are the things that we need to talk about, though, because USCIS has to be informed of these things that has happened to you in order for you to get those benefits that you are entitled to. Okay. You're going to explain your role, who you are as a summer associate or the supervising associate or partner. You're going to say who you are, what you're going to be doing with them. It's always good and important to always let them know where everybody's roles are, what's going to happen, lay it out for them step by step. This is what we're going to do today. This is what we're going to do tomorrow or next week. I will be calling you. How often will you be calling? What are the best times to call you? When can I not call you? Some of your clients may still be living with their abusers. So please be mindful of that and ask them, when is a good time to call you? When is the best time for you to come and meet with us? Are you going to be in danger if we do X or Y? Okay, so just always be mindful of that. If your client is in extreme emotional distress and cannot speak to you guys whatsoever, give me a call. We'll talk, and if you think that she needs further counseling, you could refer her to our social work services, and we can try to match her up with some counselors as well. We do some safety planning, et cetera, et cetera. So again, gauge where your client is in terms of her mental emotional state, and if she does need more counseling or more services, you can always refer her back to us. We do have a YouTube video on working with survivors of intimate partner violence, so you guys can watch that here too. But I'm not going to show that now. So any questions on domestic violence? It was a very short overview. I mean, we can have a 3-hour training just on DV, but that's not what this is, so we're moving on. Any questions? Okay, so here on out, we're going to talk about immigration law and the VAWA self-petitioning and the battered spouse waiver process. So this is, I'm going to give you a very, very, very brief snippet of overview of immigration law in general, because immigration law is expansive, it's massive. There's all different types of areas of it. There's employment, there's asylum. You could see you see all that. What we do at Her Justice is a very small piece of that. It's called the humanitarian-based cases. And so I'm just going to give you a very, very a brief overview. So until 2003, it was all one agency, INS, Immigration Naturalization Service. And this was before 2003. And in 2003, they split everything up and put it all under the Department of Homeland Security, which is under the Department of Justice. And within that, you have three separate departments here. You have U.S. Customs and Border Protection, CBP. CBP are the folks at the border when you come in with your passport, when you went on a trip to Paris or where have you, you come in, you show your passport, they say, oh, you're a U.S. citizen, oh, you're a green card holder, oh, you have a visa, please come on in. Or they're also folks at the southern border when you're coming in and seeking asylum. The CBP officers are the ones that are checking your papers. Citizenship and Immigration Service, USCIS, those are the folks that deal with they're the administrative arm of Department of Homeland Security. These are the folks that you will be dealing with. These are the folks that you will be sending all of your papers to. And then we have ICE, which is Immigration Customs Enforcement. And, you know, when you hear of ICE raids, you hear of ICE in the courts. These are the folks that are there to arrest immigrants or unlawful immigrants or undocumented folks, to put them into detention and to remove them. The one thing to note about CBP has jurisdiction to do the same thing as ICE 100 miles within the borders, okay? So that means upstate New York, parts of like even New York City, depending on where you say the border is, because we are in the water here. So CBP can, and they do, board trains, buses, and asks for ID, and they can detain you as well. So just something to be mindful of when you are advising your clients about traveling even within the United States. So immigration categories, we have non-immigrants, immigrants, and citizens. This is kind of like the spectrum of where people move from. So non-immigrants are people who are here for a short duration of time. They're not here to live here permanently. They're here because they're students, they're tourists, or temporary workers. They have authorized limited stays because maybe they're here with an embassy or as a government worker from another country. And then all undocumented people are also non-immigrants. And then you have your immigrants. Immigrants are those folks that have lawful permanent residency, green cards, people who are here to live and work permanently in the United States. They pay taxes, they can travel in and out of the country. There's one thing they cannot do that a citizen can do, which is, anybody? Vote, yes. And there's one thing that can happen to them that will never happen to a citizen, which is, very good, deportation. So, yes, lawful permanent residents can be deported, and they cannot vote. But otherwise, they can move freely in and out of this country. They do pay taxes, and they live here under with acknowledgement from the U.S. government. And then we have citizens. Citizens are folks who are born here, or folks who have been lawful permanent residents for the required number of years, and they naturalize to become U.S. citizens. And then you have acquisition and derivation. Those two terms basically are you get it through your parents if you're under a certain age, or if your parents got it before you were a certain age, things like this. So those are the two other ways you can do it. Any questions on this spectrum here? So what we are trying to do is either get your client from a non-immigrant to an immigrant, or if in the case of a battered spouse waiver, they are already an immigrant, they are in that second category there, but it is conditional and it is temporary. So we're trying to move that forward so that they do become permanent residents and not just conditional lawful permanent residents. One thing that is happening, and you may have heard about it, is that citizens, this administration has started a denaturalization office. It didn't start it, they're just ramping it up. It's been around for a while, but now we are hearing more and more about denaturalization happening to folks that did get naturalized. This is crazy, but if your clients say, hey, look, I heard that even if I get my citizenship, it can actually be revoked, they could take it back. Yes, that is true, but that is true if there was something wrong with that process to begin with. But again, immigration, the government is looking at everybody, even folks who did get naturalized. As they are renewing their passports, they are being flagged. So just be aware. And I think later on in this training, I think we do talk a little bit about the current climate and what it means for our clients. But for now, let's keep moving on. Okay, so ways to obtain lawful immigrant status. We have family, so you're a family member, you could get it through your family members. Your family member is a U.S. citizen or lawful permanent resident. They can sponsor you and they can bring you in. Family members means mostly immediate relatives, mom, dad, sister, brother, like siblings, okay? And that's about it. You cannot sponsor grandparents. You cannot sponsor aunts, uncles, cousins. Okay. The next category is employment. Employment-based is there's an employer that, and you say, hey, you know what? Akin Gump says, we want to sponsor X person from another country because we think they're going to be an amazing attorney here and we really need them. So Akin Gump can sponsor somebody and you can come in through your employment sponsorship. Visa lottery was created many years ago because the government decided, hey, you know what? There's like some undersubscribed countries, like places in Western Europe and other countries where we just don't have a lot of people from those countries coming in. So if you are from a certain country that is named and you say, hey, you know what, I want to be part of this, and you put into a visa lottery. It is like the lottery. It is really, really difficult to get this, but people do come in through a visa lottery. A lot of folks from Eastern Europe came in through visa lottery right after the Soviet Union kind of broke apart in 1993, and beyond into early 90s to late 90s, a lot of Eastern Europeans came in through the visa lottery program. Humanitarian base, this is what we do. So it's the VAWA petitions, it's the crime victims with the U's and the trafficking victims with the T's and the asylees, refugees. That's all where the humanitarian bucket comes in, and that's what we do. So here we go, impact of the executive orders. This is what I meant when I said, okay, what is going on in now with this administration? So in 2017, shortly after he was inaugurated, after the inauguration, President Trump decided to do a lot of executive orders, targeting immigrants. And what does it really do? It's creating enforcement priorities, including people who have any criminal convictions, charges, or committed any criminal acts, engaged in any fraud or willful misrepresentation. And it's requiring the prompt removal of anyone whose legal claims to remain have been denied. Basically, it's targeting anybody who is here undocumented. This was in the first group of, the enforcement priorities came out in the first group of executive orders, and since then there have been increasing more and more executive orders that have come out to say, basically, if you're here without documentation, even if you are a visa overstay, you are now an enforcement priority because you are not here with any kind of permission from the U.S. government. Visa overstays were the least of the problems of immigration, of folks who are here unlawfully. People came in on a visa, they never left. And they were never the target, but now even they are the target. So anybody who is here without documentation, you're gonna be a target. What are our clients hearing? Our clients are hearing all kinds of things up there. Everybody's getting rounded up. You hear about the southern border crisis. It's really apparently not that much of a crisis. They said it was, depending on who you hear, what news channel you're hearing it from, it's going to be a crisis or it's not going to be a crisis, right? So pick and choose. In my opinion, it's not a crisis, or if it is a crisis, it's a crisis that was created by this administration. But be that as it may, it is an issue, and our clients are being targeted. Immigrants are being targeted. And how this will all play out, we don't know, because it's not only in these executive orders that are coming out, but it's trickling down into the whole system. So USCIS now, like I said, they're being very, very meticulous, very, very problematic, in my opinion, in terms of the way they are adjudicating these things. They're going through it with a fine-tooth comb. Things that were being okay and approved like 5 years ago, that's not the case anymore. We're getting increasing requests for evidence, we're getting increasing denials, we're getting increasing notices of intent to deny. So this is why we always tell our associates, when you're working on this, you do want to put your best foot forward. You want to make sure that everything is there, and you need to paint the big picture and also get into the weeds for them, because that's like they're being very, very meticulous, I would say. Okay, any questions on this at all? One thing that you will hear, and I'm going to tell you a little bit, I'll tell you this now actually, is there have been implementation memos, like policy memos that say, hey, we are no longer going to be sending out RFEs if you guys don't give us necessary documentation. We'll just deny it on hand if you don't give us the necessary documentation. So if you mistakenly leave out a form, instead of asking you for the form, they will now deny you. And once they deny you, they're saying now, once a denial is there, then you will also get a notice to appear, which means that you will be in immigration court. So they're trying to make this process, they're saying they're streamlining the process, making it faster. In our opinion, what they're doing is not streamlining our process, but actually clogging up the immigration courts, causing more panic where it's not necessary. But anyways, that's my opinion. Yes? What's an RFE? RFE, we'll get into that in a minute, but it's a request for further evidence. And again, when we get to that point, I'll reiterate what I just said as well. Okay, so obtaining immigrant status. What happens? Usually, and I have to do a little bit of a comparison of what's the normal route and the other route that we're going to be doing. So step one, usually on a family petition, it's going to be a petition for alien relative on form I-130. And then the step two is adjustment of status application, form I-45 or consular processing. So you could always look at getting your green card as a two-step process. It's always a two-step process. One, the first step is you have to have a qualifying qualifying relative to be able to sponsor you. And the second step is adjusting your status if you're here in the United States, or you do consular processing through the U.S. consulate in the home country. Okay. And in our process, the VAWA self-petition process, it is a form I-360, and then the second step is the same. So basically, step one is what is different. Why is step one different in our process? The self-petitioner is in control of application process. If you look at this, step one in the family base, it is the family member that petitions. So if you have an abusive spouse, what happens? Anybody? Fatima. Exactly. If you have an abusive spouse, they can refuse to petition for you. They can use that as another form of power and control over you to say, oh, guess what? I'm not going to petition for you. You don't listen to me. I have this over you. You will always be undocumented, and I'm going to report you to. And now more than ever, people are believing this, and now more than ever, it is actually true. Where you call ICE and they will come and investigate. Okay, before they used to not do that so much. Even if you called somebody, they wouldn't investigate. But now they will come and investigate if you say so and so is here and they are undocumented. So again. That process, so the benefits of the VAWA, the self-petitioner is in control of the application process. I can petition for myself as an abused spouse. There's a safeguards of confidentiality. If you file for the VAWA self-petition, USCIS or ICE or any government agency is not supposed to go off of any information that is provided by the abuser. Okay, so if an abuser calls and says, oh, I have an undocumented person living with me, et cetera, they're not supposed to use that information to go after this person or have any negative consequences about this person. That is in law, that is in regulations. However, what we have heard from immigration when we have actually caught them doing this and saying, hey, look, this person is a VAWA self-petitioner or has these protections, they would say, well, it wasn't from the abuser. We did our own investigation after that advice, like somebody gave us that information. We did our own separate investigation, and we are going after this person on our own separate information, which is, we all went to law school. There's like fruit of the poisonous tree thing going on, but they seem to think it's okay. And so they kind of have given us those excuses when we do question them on these kinds of things. So again, the other thing about benefits of VAWA is you get the work authorization, and obviously this gives you economic independence. Okay, so what are the requirements for the self-petition? Who qualifies for VAWA relief? If you are an abused spouse of a USC or lawful permanent resident, and this includes their children as derivatives. Non-abused spouses of United States citizens and lawful permanent residents where child is abused. Abused children of United States citizens and lawful permanent residents, and abused parents of adult USCs over 21. Your bucket is going to be that first bullet point, okay? Those are going to be your clients here. Okay, the elements is immigration status of the abusive spouse, which is that they need to be a what? U.S. citizen and or LPR. Okay, and then you have to have a legal valid marriage. We're going to go through each of these elements in a minute. Legal valid marriage, good faith marriage, shared residence, qualifying abuse, that is battery or extreme cruelty, and good moral character. Okay. So we're going to do a little bit of a case study so you guys can, it'll be more interesting, I think, than me just talking at you. So Victoria is originally from Ukraine. You can take some notes because I'm going to ask you questions about this in a minute. Victoria is originally from Ukraine. In 2012, she met Sergey when he was visiting family in Ukraine. Victoria came to the United States on a tourist visa in 2014 and decided to stay and moved in with Sergey. Since she didn't know many people in the U.S. and hadn't been to the U.S. before, Victoria relied on Sergey for helping her get used to living in the U.S. Sergey went everywhere with her, even after 6 months when Victoria started taking English classes. He insisted that he take her to the classes and pick her up afterwards. He asked her about this to her friends and who she was making and who she was hanging out with in school. He would look through her phone and contact us to see who had called her and whom she had called. Victoria started to limit her calls home to Ukraine because Sergey told her that he could not afford to keep buying her phone cards. Soon, she was only talking to her parents once a month, and Sergey insisted on either being in the room or talking to them as well. Outside of her English classes, Victoria could only leave the house if Sergey was with her because she didn't have a key to the house. He told her that he didn't have an extra set of keys for her, and the landlord wouldn't allow him to get one. So, okay. I'm trying to scroll down and, sorry. Okay. Therefore, during the day when Sergey was at work, Victoria had to stay in the home. Victoria and Sergey eventually married in 2017, and he has promised to file her immigration papers for her, but has continued to put it off, saying that he doesn't have the money right now. However, whenever the two argue, he brings her status up to say that she's illegal in this country, so she better watch out. Sometimes the arguments have gotten physical, and Sergey has pushed and shoved Victoria. Once, when Sergey slapped her across the face, Victoria pushed him back and kicked him to make him leave her alone. Okay, so that is Victoria and Sergey. So, if you were to look at Victoria's case, would you say she is eligible to file a VAWA self-petition? What do you guys think? Yes? No? Yes? For sure? Do we need any more information? What about Sergey's status? Did we say what his status was? We don't know his status. So as long as he is a U.S. citizen or a lawful permanent resident, yes, that element is met. So how do we prove Sergey's status? His birth certificate, his passport, other immigration documents that he may have. What else? Other official documents. Say that she doesn't have access to his birth certificate or his passport. He was born here, though. So if he was born here, it would say maybe she could get it through when we say other official documents. Marriage certificates in New York City, marriage certificates will have the place of birth of both parties. So if he was born in the United States, that's what it will say. Okay? If all else fails, what you can do is ask USCIS to research or search in its records. As long as this person was a naturalized U.S. citizen and or has gotten a lawful permanent residency or is a lawful permanent resident, USCIS will have some record of this person. The hardest people to prove their status are people who are born in the United States. They get married outside of New York City or New York State, and so, or it's a marriage certificate that doesn't have the birthplace of the person, and they never applied for a passport. Those are the people that is harder to prove their residency than anything else. But again, we do it by secondary evidence. The standard of proof here for a VAWA self-petition is any credible, relevant evidence. That is the standard of proof that you are working under. So it's any credible, relevant evidence. So you would say this, I don't have, say that, for example, your client doesn't have a copy of his passport or anything, but she knows that he is a permanent resident, or she knows he's a U.S. citizen because he told her that. So she would say, I know that he is because on XX date he told me he was, or I saw a picture of his passport, or I know I've seen his green card, but I just don't have access to it. So you have to show these things as much as you can. If whatever evidence you cannot have, you do not have in primary evidence, you could say it by secondary evidence, and then also through just for affidavit. But again, the more you have, the better it is. So the primary evidence, in terms of these kinds of things, if you have primary evidence, it's better. And then the next thing is proving legal valid marriage to a USC. So Victoria and Sergey, they got married in New York. So could you do this? Did she fit this element? Yes. Marriage certificate, judgment of divorce, English translations of documents. So judgments of divorce. Legal valid marriage means that you cannot have been married to somebody else when you married this person, right? Or that other person could not have been married to somebody else when you married him. However, there is a bigamy exception to the VAWA self-petition process, which means that I married Eli, but Eli was already married to somebody, and he never told me he was married to somebody. But in my belief, Eli wasn't married, and so this is where the bigamy exception comes in, okay? I, as a self-petitioner, if I relied on my abusive spouse saying that he was divorced, it's okay. However, I married Eli, okay? Eli doesn't have another spouse, but I did in my home country, and I never divorced this person. Guess what? That bigamy exception does not count, and I would not be able to petition, okay? So your client, if they have been married previously, needs to have a divorce certificate from her previous marriage. And a lot of our clients, they will do this too. They will say, well, in my home country, we have common law marriage. So I was living with this guy for 10 years and he's considered my husband in my country. But even through common law marriage, there is no such thing as common law divorce. Okay? So if you really did hold yourselves out to be man and wife through a common law marriage, you still have to get a actual divorce, even in home country. Okay? Most of the times. And a lot of times we do have people research this issue for the domestic relations laws of XYZ country, but most in our experiences, most of them have said there's no such thing as common law divorce. You would have had to have gotten a legal divorce.
Does the government agency know if the applicant is married in her home country?
They wouldn't. So this is where you control the record. But if they tell you, you now know, so you have to put it forward. Right? So this is where it's, they wouldn't know. Like this is really interesting. This is a very good question because a lot of the things that we tell our clients are very truthful, and we try to be very truthful, and we tell the client's story as it is. And so we say, oh yes, and she was arrested on this date, whatever. Well, part of the good moral character, right? I was arrested this time because of this, and it's really no big deal, and they would never have known that because there's no record of this arrest because it was misdemeanor, it was dropped and all this stuff. And then the government comes back and says, well, we not want all the records of this. And they would never have known unless you said this to them, right? But because you know, and you can't lie to the tribunal, like it's your ethical obligation to put the story forward as it is. So in order to prove the legal valid marriage, you have to say, I was married and then divorced. If in fact she was married. Do you understand what I'm saying?
Why wouldn't a better practice be don't ask?
Well, I mean, you can not ask, but can you give your client's full story that way? Because you have to put a good faith marriage. It's going to be legal valid marriage, and the next point is going to be good faith marriage. So in telling the good faith marriage story, this usually comes out when it has to come out in some way. I mean, I guess you can always not ask and don't put anything in there and just start from the day that she meets her husband, which, a lot of clients want to talk about their backstory. But once they tell you their backstory, then you kind of have this obligation to talk.
I thought good faith marriage meant they were trying to exclude the sham marriage.
They are, but that is true. And here's the good faith marriage, and we're going into that right now. They are trying to avoid the sham marriage, and unfortunately, the good faith marriage is where USCIS has sunk their teeth in on the VAWA self-petitioning process. This is where they're going through saying, you got to give us the nitty-gritty, boring details of your courtship. What did you do? How long was it? Where did you go? If you just say, I met him and we went on a couple of dates here and there, they want details. They want all kinds of boring, nitty-gritty details of that it was a good faith marriage. It can't just be we met and we got, and which is kind of crazy, because if you do a I-130, the family-based petition, they don't really sink their teeth too much into the proving the good faith marriage as they do in the VAWA self-petitioning process. Here, for whatever reason, they basically want everything. Like from the time you met this person to the time you separated from this person, they want to know why it was a good faith marriage. And again, it should be, hey, if it was for any other, I got married to this guy and the sole purpose was not because of immigration purposes, then that should be enough. That is what the good faith marriage is about, is that it was not for immigration purposes. It doesn't have to be about love. But for some reason, USCIS has decided to make sure that that's part of the requirements, is that you got married because you loved each other and wanted to have this life together. So, yeah.
So when you have a culturally arranged marriage, that satisfies?
That one is the best way to satisfy the good faith marriage, actually. It's the easiest way to satisfy a good faith marriage. You don't have to say a whole lot. They don't care about the length of the courtship. Like many times the culturally arranged marriages tend to be a very short courtship, like within weeks to months, and that's about it. And on those are the ones that we have gotten the least amount of pushback about the good faith nature of the marriage. Yes.
What do you do in a situation where it's a culturally arranged marriage, family, questions the matchmaker in America? On their end, they might have had an intent of finding an American for the purpose of immigration, but that might not have hurt.
So it was for purposes of immigration, or is it because they just wanted her to have a better life? Quote unquote, a better life. Yeah, so it's not her intent. It's got to be her intent, right? So if her intent was never because of immigration purposes, and it was like her intent was, okay, I'm going to get married to this guy because my parents have decided that I got to marry this guy, that's enough, as long as it wasn't her intent for immigration purposes. Right? Any questions on this? So again, back to the question of why would you say something in the record, is as the story unfolds, things will come out into the record, and then you have to explain them. Right? So as long as you can try to keep it out of the record because it's not helpful, you don't have to put it in there. Okay. Is there an interview associated with the VAWA self-petition? No, there is not. This is why this is all done on paper. The VAWA self-petition, this step of the process is all done on paper. They will never meet you. They will never meet your client. So they will not know that, she may not be able to talk about these things because she's so affected. So this is why when you put this stuff out and when you're writing that affidavit, you need to be very, very thorough about it, because that is the only thing they're going to see is what you're putting down on paper. You're painting your client's picture and everything to them in this affidavit of hers. Okay. So again, it's going to be in the self-petitioner's affidavit, intent at time of marriage. So going back to that, right? What's her intent? Her intent was to get married to this person because her family arranged it. And any and all evidence that shows that self-petitioner intended to establish a life together. Sometimes we get, so people say, I don't have anything because he controlled everything. I don't have bank accounts or joint bank accounts or life insurance or things like that to show like what we would traditionally think of as a good faith marriage documents, right? You want to live with this person, you're going to have a life with this person. So whatever is you don't have, you have to explain why you don't have it now. In the past, it wasn't that you needed to explain so much why you don't have certain documents. Now they come back with a request for further evidence saying, hey, look, we need, we see that you sent XYZ. However, we still don't believe it was a good faith marriage. So if you have XYZ more things, then send it to us. If you don't have it, you're going to say why you don't have it from the get-go. So we don't have life insurance because he never thought that he didn't want to give me any benefits. We don't have joint bank account because he controlled all of the finances. We don't have a car insurance because he was the only one who ever drove the car. I didn't know how to drive a car. Whatever it is that she does not have access to, and why she didn't have access to it, is what you want to put in terms of the traditional documentation that it would be to show good faith marriage. But there's the atraditional documentation that you could show, right? Such as Facebook, email, Twitter, whatever it is. If they're exchanging messages back and forth before they got married, talk about those. You could do screenshots of those text messages going back and forth about how much I love you. Okay, there's some that are really risque. Don't put those in, okay? You don't need to put that stuff in, but you can definitely put in things that are like, oh, I'll see you at this time. It was great to meet you, whatever, when they first meet, etc. Pictures, children and family gatherings, involvement, things like this. Definitely, if you have pictures, it's better to have groups, people, and them in groups of with other people instead of the two of them, because immigration has also pushed back and said, oh, well, this shows that it was a time and place, but it doesn't really show anything else besides you guys taking a picture together. And they feel like, people pose for pictures to scam the government. So if you have them in groups of people, pictures with other people in other gatherings, other kind of life events, it's much better. You will have a photo affidavit. If you do include photographs, you do want to have a photo affidavit explaining what each photograph is and where it was taken. Clients have tattoos of their spouses, like names and things like this. So if they have that, you can also, take pictures of that. It's not in a weird, risque place. Okay. Any questions on this, good faith marriage or anything like that? Any of the other elements that we talked about so far? And then you have to show joint residence. Joint residence and good faith marriage, some of the things overlap. Joint bills, leases, affidavits from friends and family, roommates, marriage certificate, mail, anything that shows that these two people cohabited in the same place at the same time, that they lived together for at least a short period of time. There are times when people live together for a week, and abuse happens, and then they say, you know what, forget it, I'm out of here. Eli had a case like this, right, where they lived together very short. They went on their honeymoon. He was absolutely abusive on their honeymoon, and she left. And they literally lived together for a week. So what do you do with that? You have to say why it was such a short period, but that they actually lived together. She had her intention to have a joint residence with this guy, and they did live together, even albeit for a very short period of time, but she wasn't going to sit here and continue to get abused, and so she decided she was going to leave. Okay, so you have to explain. Again, there's no minimum period of joint residence, but you just need to show some kind of joint residence. Even if it was they were jointly residing only on their honeymoon, like for 2 weeks in a hotel somewhere, okay, you could show that. And then you have to show proving qualifying abuse, battery, or extreme cruelty, and this is all going to come in the form of the affidavit or police reports or orders of protection if it was physical and it did get into, she called the police or went to family court to get an order of protection. Okay. Any questions on that? Yes?
Include photos of bruises, cuts, scrapes, that all gets included as well?
Correct. Photos of bruises, cuts, scrapes do get included as well. A lot of clients do take pictures, and they might have hidden their picture somewhere in their phone. I mean, it's amazing in this day and age where it's all digital, so it's great. In the past, we used to have, I've been doing this for a very, very long time, and a lot of my clients, in the very beginning when I was doing this, I would say, do you have pictures? They said, no, I threw them all away because I was mad. So anything that was jointly with him, I just threw it all away. The only thing I have are these pictures of these bruises, which always helped. But again, like, it doesn't help in the other elements, right? she doesn't have any kind of good faith marriage pictures because she threw them all away. Nowadays, everybody keeps everything, so it's good. And you could go through their phone and ask them for permission to print things out. Any questions on the 5 elements here? Okay. And the last one is proving good moral character. There's a 3-year look back on good moral character, and you get a certificate of conduct from a place, any jurisdiction where your client has lived 6 months or more in the last 3 years. Okay. One thing to note is that the NYPD certificate expires in 60 days. So if you're going to get the NYPD certificate of conduct, and it's all in your manual, how to get this and how to obtain it and how much it costs and everything, but it does expire in 60 days. So what we do is we ask that you send your client down to get her prints taken and get that certificate of conduct towards the end of the time when you're about to file it, okay? Because, again, it expires, it costs money, they have to go back, and it's a 10-day turnaround time. If your client has been arrested, we have tried to get as much information as possible during our intake with the client. Before we place your cases, I'm sure most of you have seen, you have an extensive case file, and we have tried to give you as much information as possible. We do try to front load all of the evidence for you guys, and you just kind of putting in the missing pieces there. So look at your client files if you do have criminal cases, or maybe during your interview with her, she forgot to tell us that she was actually arrested and there was a criminal disposition. Talk to us and we'll talk about getting that criminal disposition. Sometimes client doesn't say anything. She goes to go get her good moral character done. Prints come back and it says arrest. And then she's got an open warrant. I think there's a case here at Akin that this happened. They were about to file it, and then they found out that she had this arrest, and it was an open warrant, and they had to go try to deal with this open warrant. You can't file that way. And then for good moral character, also you're going to look at INA Section 101F, and that's going to be where all of the good moral character grounds live. And any questions on good moral character? Yes.
So is that 3 years for everything, or is the 3 years just about the conduct certificate?
The 3 years is about the conduct certificate.
So they have to have good moral character the whole life.
Well, they should, but actually, like the good moral character for VAWA purposes is 3 years look back. However, USCIS has said we are able to look back further than that if we want to. So if it's like she did something really horrible 10 years ago, they can actually use that really horrible thing she did 10 years ago to say, yeah, we know it's 10 years ago. However, it still like goes against her good moral character.
But our criminal disposition records and evidence go back forever.
Yeah.
Even though the look back only
Yeah. Yeah. But the New York City one only looks back 3 years. If you do the New York City one, if you do an FBI check, it will go back many, many, many years. Okay, so that's like something, and sometimes we say do the FBI one because it doesn't expire, it comes back quickly, it's not as expensive, you don't have to go down to NYPD. A lot of people are afraid to go down to a government office right now, so the FBI one, all you do is take prints, and you can do the prints in, Her Justice will do the prints for you, so you can do the prints, and then the prints come back, but you also run that risk of it's gonna look at every single place that you've ever lived, and even if you have like a border, interaction. So they'll look at that too. So that's, but you could talk to me or you could talk to Her Justice mentor about the advantages of either or. Okay. Any questions? Yes, Fatima. Exactly. Anywhere. So like a lot of clients, a client may have come in just recently. Maybe she moved here, from her home country last year. She got married. So you're going to have to get a good conduct certificate from home country. And depending on where home country is, it's easy or not so easy. We had one case where it was in somewhere in the Caribbean, like St. Martin, I think it was. And I kid you not, our request for a good conduct certificate went from each island to island, and we're calling, like, oh, we know yours. We've heard about this request making its rounds, and we finally got to the right person because I asked somebody who spoke Dutch to please call, and she was able to kind of figure out what was going on with this. So again, depending on the country and depending on where they're coming from, it may or may not be that easy to get that good conduct certificate from the home country. Okay, and that's only if they came in the last 3 years. Okay, okay. And again, like I said, the standard of proof is any credible evidence, and it's by preponderance of the evidence. And you're going to see section INA, section 216C4. INA is the Immigration Nationality Act. I'm going to read a quick code because for those who are going to be watching this by video, it's A as in apple, B as in boy, 349. That's AB 349. Okay, so. Let me just check time. Do you guys want to take a quick break or keep going? Up to you. Keep going? Break? Okay. Okay, let's take a 10-minute break. 5-minute break. Let's do a 5-minute break. Thank you.
Okay, cool. So do you want to do morning? Yeah. Okay, we'll do a morning. No, I think you guys have the same thing with the forging.
Right. Last night where I slept, I didn't charge my mind now, but I just passed out. And I've been playing catch up.
Oh, yeah. Well, you know, like, were you at the lunch and learn experience?
Yeah, I just
We met with them. Have you ever seen in Red Dragon or Kids or Dragon?
Wow, dude, I'm worried about I'm not like my phone was on full. Like just fine. I would have slept till like 11. Honestly, I wish I had. It would have been ridiculous.
Yeah, so what is just edible? The dragon one is so good. It is literally one of the scariest ways to read it. And you should watch it.
Uncomfortable.
Yeah.
My favorite movie ever. Is it really? That's terrifying.
It's my dad's favorite. But you should watch this. Have you seen what I'm talking about? What's it? Prequel, something dragon, Rising Red Dragon. That shit's scary, right? I think it should.
What happened?
Well,
Dragon?
basically, basically a guy is like real and like thinks that he's you know outline of like spirit kind of thing that is really cool, and he goes and like document that has like the dragon on it. That's such an
I'll have to watch it while we're. You're Christine? Oh, you're Christine. I'm sorry. Mike, nice to meet you. Pleasure. You're starting with us this summer, right? Cool. Welcome.
Yeah. I've actually did this training.
I'm dropping the ball. That's really cool. And it's like, I'm very silly? I get it. What's on the jacket? What? What's on the jacket? Leather jacket. Scorpion on the back. It seems very like 70s. We're all busy, like,
Okay, we're gonna come back. There's a lot to cover. Okay, we're gonna go back to Sergey and Victoria. I should have brought some swag with me to hand out if you guys answer questions, but I didn't. I'm sorry. Next time I'll know. And we'll do it more like a game show. So, okay, Sergey and Victoria were married in a religious ceremony in Brooklyn, New York in 2017. They were civilly married at the Ukrainian consulate in New York City that same year. Sergey controlled all the finances and everything was in his name only. They do not have a joint bank accounts or joint bills. He did not include Victoria in his tax filings either. They had a child in 2018. So, what would you guys put in for evidence if Victoria was your client and you were doing a self-petition for her? What would you put in for evidence? Marriage certificate, birth certificate of who? The child, yep. What else? Photos from the wedding, yep. 2 weddings, right? They had 2 weddings. And the reason why I put in that this hypo says Brooklyn, they're married in a religious ceremony in Brooklyn and then civilly married at the Ukrainian consulate is because if you only have a religious ceremony in New York, it is not a legal marriage. Okay? They do not count that as a legal marriage. So you cannot have only a religious ceremony. A lot of people have proxy ceremonies, proxy marriages, also not a legal valid marriage, as it means in New York State, okay? So if it was a legal valid marriage in the state that they were married in, it's okay. But if they did it here in New York, it's not gonna be okay. Yes? What's a proxy marriage? Oh, proxy marriage is if like somebody's on the phone here and then the spouse is in another country, that kind of thing, or in another state. It's like, that's what you do when we do. Sometimes people have religious proxy marriages because it's an arranged marriage and the parties are not in the same place. So again, the religious proxy marriage does not work unless you actually also have a civil marriage somehow. Okay? Any questions on that? So again, they got civilly married in the Ukrainian consulate in New York City. Does that work? Yes, that does work because that is actually registered as a marriage in Ukraine because it's in the consulate, but it is still a marriage for purposes of this. It's a legal valid marriage here. I've had cases where clients their families got married in home country. They married, it was like a cultural thing where the families decided to get married. Both parties were here. The families decided to get married and they did this whole ceremony in home country. And then the parties just went to the consulate here. I think it was the Mali, or is it Malawi? One of those 2 countries. They went and they did the civil marriage and it was fine. So that's what you need to show. So it has to be not just a religious marriage, but a civil marriage as well. Anything else that you would include to show good faith marriage or joint residency? The religious marriage? Mm-hmm. Actually, absolutely. Affidavits from anybody who was attending. Because what do we not have here? We don't have any hard proof of their joint residency, per se. We don't have any hard proof of like a good faith marriage in the form of tax returns, joint bills, joint bank accounts. So because those are what people think, USCIS is thinking of traditionally as good faith marriage documents, you have to show other ways of proving this. Now, you have all of this when you're showing, well, we'll go through this and I'll talk about like what kind of evidence you're going to, I mean, when you put in your evidence, what you want to consider as well. Okay, so the petitioner's affidavit. You as an attorney control the record. We were talking about this earlier, right? You as an attorney control the record. Your job is to ensure that the record is consistent and complete. It is organized chronologically, usually from the time there used to be a time when we had to prove that this person entered legally and validly. You do not have to prove that anymore. So you do not have to go into the history of how she came in and when she came in. You can actually just say, I met my husband so-and-so on X and X date at X and X place. And this is how we met, through friends, what have you. You do not really need to go through all of the other background stuff if you don't want to. If it helps to paint a better picture of who she is, where she's coming from, and you think that it will help in for the adjudicator to understand her better, please put that background stuff in, but it's not necessary. Okay, and you're going to address all the required elements, right? All the 5 elements of the spouse's status. The good faith marriage, the joint residency, the abuse, and the good moral character. And the good moral character usually is going to be, I'm a person of good moral character, I've never been arrested, I've never had any problems. Or, I'm a person of good moral character, I try to abide by the laws of any place that I am living. However, there was one time when this happened. For example, say that, remember in the very first part of my hypo, what happened? We had where Victoria actually kicked and hit Sergey to make him back off. Say that he calls the police on her. And in New York, there is a mandatory arrest policy. So if they do not know who was the primary aggressor, they will arrest both people. Say that she was arrested at that time. You would put that in there. I am a person of good moral character. However, there was one time when I was arrested because XYZ thing happened. I'm so sorry. That was the only time this has happened. I have since that time, and that case was dismissed, what have you. We have a lot of, I was left holding the bag kind of scenarios for a lot of clients. They went shopping with a friend. Friend says, hey, hold my bag. They go to the bathroom. They come out. They're walking out the door. And guess what? That bag that the friend asked them to hold, it was full of stolen merchandise. And so now your client is the one that has problems, and she was literally left holding the bag. So those are the things where you want to explain certain things that have happened, okay? But again, when you're doing your affidavits, you need to be consistent, plus the details, that's credibility, that equals credibility. Because, as I said, this is the only chance that you're going to be able to paint your client's picture to USCIS. And so when you're preparing all of these the evidence, what you want to do is, in the past, I used to say, just put everything forward with the eye that you want to put your best evidence forward. Everything's going to be in there. Don't hold anything back. If you have 5 affidavits from 5 supporting affiants, put it all in there, Or you don't need to get all 5, maybe you only need 2. However, these days, because USCIS is becoming more finicky about adjudicating these, and they are sending more and more requests for evidence, because they're questioning the good faith nature of the marriage, the abuse, etc. What we are telling people to do is think about it with an eye of responding to an RFE. So if you do have an abundance of evidence, you might want to hold a couple of things back so that in case you do get an RFE or request for further evidence, you have something to give them. Because if you've given them everything and they come back and say that's not enough, what are you going to say? You're going to say, well, we gave you everything we have, so if you don't think that's enough, then all you're going to be able to do is give another affidavit, another supplemental affidavit from your client. So we're telling everybody, because the way that USCIS is adjudicating this, and they're becoming more strict in their view of what all of this means, you definitely want to think about maybe holding a couple of pieces of evidence back, and then so that you can respond to a request for evidence if and when that comes in. Okay. Any questions on that piece? Okay, so children, any questions on any of this so far? We're going to now move on to what other effects that children, divorce, death, and remarriage have on the VAWA sub-petition. Okay, children of VAWA sub-petitioners, derivative beneficiary. They are considered derivative beneficiaries. Children in immigration land is unmarried and under 21 at time of filing. Children must remain unmarried until after the adjustment of status, which means that until after they get their green card. And there is something called an age out issue. Okay, you need to file if you want the children to be derivatives. It needs to be filed before the child turns 21. Okay, it's absolutely important if you do have derivative children that to be included as a derivative child that the application has to be filed before the child turns 21. And because we have derivative children, there are duties owed to both principal and derivatives, loyalty, confidentiality. There may be a conflict of interest. Your engagement letter should reflect some of this in there, depending on what exactly you will be doing for that derivative child. Sometimes the derivative child is just checked off on a box if you're doing it only in I-360, okay? However, if you're going to be doing the other applications in I-485, which is the green card application, and or the employment authorization for that child too, there is going to be a dual representation or multiple representation. So that's something that to be aware of. Okay? And sometimes conflicts of interest do arise if there's a conflict between the mom and the child, right? Maybe child beats mom or mom beats child, and all of a sudden there's like this court case against each other. Or, ACS becomes involved or what have you. So those are the things that we do want to be aware of and mindful of. But usually it's not going to be an issue. Then what does the impact of divorce and remarriage? Okay, say that your client is still married to this person, the abuser. She's separated from him, and then they get a divorce. If you have already filed it, the self-petition, there is no impact. Okay, it's okay to get a divorce while this is going on, while she's filed it. If she is divorced before the self-petition is filed, none of your clients are in this boat, I don't think. But if they are divorced before the self-petition is filed, then you have a 2-year filing deadline. You need to file 2 years within the time of the judgment of divorce being signed. So say that I got divorced from my husband, and he was the abusive spouse, and I got divorced from him in December 2017. I have until December 2019 to file my self-petition. Otherwise, I am not eligible anymore. The grounds for divorce are irrelevant. It's okay if I get divorced for irretrievable breakdown of the marriage. It's okay if I get divorced for abandonment. It's okay if I get divorced I don't have to get divorced because the reasons are cruel and inhuman treatment. However, if it is a divorce that I do get and it is cruel and inhuman treatment that I perpetrated against him, okay, say I am the defendant in that divorce and he claims that I was the one that was inhumanly treating him, that's going to be an issue because it's a conflict of what you're claiming here in your VAWA self-petition. So just be mindful of that. Remarriage of self-petitioner. This is really, really important. If the self-petition is pending, okay, these are pending for more than a year now. They are taking about 18 months to 24 months to adjudicate. So a lot of clients will be divorced and now they found a new husband and they're saying, oh my goodness, I am in love again. I want to get married. What happens? You cannot get married while the I-360 is pending. Otherwise, your I-360 petition is invalidated. Okay, so if your client calls you and says, Ms. Lawyer, I really want to get married. Can I get married? And you're going to say, well, if you get married, your I-360 is invalidated. If your husband is a lawful permanent resident or a United States citizen, maybe you can do a family-sponsored petition with that person. However, there's the risks. Again, she's going to go down that same road. There's a chance that this guy is also abusive. Who knows? Or maybe he's not. So you have to weigh those options with your client at that point. If the remarriage is after the self-petition is approved, that's fine. Yes? So is there a concern for children aging out while the application is pending? No, there is no concern for the children aging out while the application is pending. As long as the filing date was before the children aged out, then you're okay. The children's age is locked in on the date of filing, that they received the file. Okay, their adjudication times being 18 months plus should not be a consequence that you have to deal with. Okay, so that is a good question, and yes, it's okay. Any questions on divorce, remarriage, children? Okay, impact of abusive spouses, loss of status or death. Maybe your abusive spouse loses his immigration status because he is deported for some kind of crime. It's okay to file it if the loss is related to the domestic violence, because he was arrested many years for domestic violence and then he got deported. Fine, you can still file. If your loss of abusive immigration status, this is in the case of the spouse being a lawful permanent resident, okay? If the lawful permanent resident gets deported because of, I don't know, controlled substance trafficking, that's not gonna help you, okay? So that deportation of that abusive spouse has to be because of, it's gotta be related to the domestic violence. If you're a U.S. citizen, if it's a U.S. citizen spouse and they die, it's okay to file within 2 years, yes. Is it a detriment to the case or an automatic disqualification? If he loses it for some other reason, it is an automatic disqualification, because they will check the status of the abuser and they will say, oh, so sorry, this guy he has lost his status. And if you can't relate his loss of status because of the abuse, then, and I mean, they will say, they may send you an RFE saying request for further evidence, or they might send you something called a notice of intent to deny, saying like, look, this person lost their status, so we are intending to deny this. If you have other evidence, please give it to us. So if you can show, hey, well, actually he was deported. Yeah, it was controlled substance. Like, that's why he was arrested and all this other stuff. But he was arrested many times because of this DV as well. And maybe that was like the multiple criminal convictions that also added to his losing his status. You could try to argue those things too. Okay. Then you have your death of a lawful permanent resident abuser. If your spouse was a lawful permanent resident and they die, unfortunately, you are now no longer eligible. Okay. Any questions? Okay, I'm gonna skip ahead here. And what to file in the 360, again, you're gonna have a cover letter. This is all, I'm gonna skip over these I'm just gonna go over these really quickly because this is all in your manual. We have samples of cover letters, samples of the forms, how to fill it out. We have blank forms, and you'll see it all. We have samples of index of exhibits, all the exhibits, all this. We have all kinds of things in your manual. Please take a look at your manual. If you have any questions, you can always give me a call. And this gets all sent to the VAWA unit at the Vermont Service Center. And please use some kind of trackable mail, preferably FedEx is the best, or UPS, something that you can get there next day. Okay, USPS, even next day, is unreliable because they usually don't do it next day for some reason. One thing to be aware of, please use the updated versions of all forms. All forms can be found at uscis.gov. So we have our manuals, and they have, we try to update them as often as possible with the most, information, the most up-to-date information. However, the forms continually get new additions on it. So please use the newest edition of the form at uscis.gov. Do not, you guys will have electronic versions of your manuals, but just don't use that form, okay? That's in your manual. Just go to this website, download it, and fill it in, okay? What happens after filing? You will get a receipt notice for sure. It will have an EAC number. And then you will also get a notice of approval or denial for sure. You may get a notice of prima facie determination. This usually comes right after your receipt notice saying, hey, on its face, your client looks like she's got all of the elements. She's met all of the elements. Therefore, she is eligible for some public benefits. You may get a request for evidence saying, oh, you know what, we looked at all of this. However, there is some parts that we are not sure of. You need to give us more evidence. They may give you a notice of intent to deny, which is annoyed, and that's saying, okay, you know what, we looked at everything. You gave us more stuff from your RFE, but we are still going to deny it. Here's your last bite at the apple before we give you a denial, okay? And then that's when you're gonna explain more. Responding to an RFE or annoyed, you will call me or her justice mentor immediately, talk about it, say, okay, well, what else can we do to supplement this application? There is a strict timeline. They will tell you when you have to respond to the RFE by. They will not give you an extension of time. And any filing deadline in USCIS's land it's not mailing out. It means receipt. Okay, so it must be mailed out 2 days, 1 day, whatever it is. They must receive it by that filing deadline. Okay, it's not the mailbox rule. It is the receive rule. Which means USCIS, Vermont Service Center, they give us mixed messages on this, but they don't open mail on Friday afternoons. So if you have a Friday afternoon or Friday deadline, okay, make sure you get it into them by Thursday, because on Friday morning they do open mail and receipt it. But if it gets to them Friday afternoon, they don't open the mail, and it will be received on Monday, because that's when they will say they got it, because they opened it on Monday, which is ridiculous. Which means then at the end of the day, you have to argue with them and saying, hey, look, I have my UPS or FedEx notice saying that it was delivered to you guys on this day. So please be mindful of it. They do not receive mail on the weekends either. So again, if you have a Friday deadline, make sure that you try to send it in by Thursday. Okay. And then worst case scenario, they may give you a notice of denial. You have 33 days to appeal from the date of denial notice. You will call me or her justice mentor. We'll walk you through that denial. We'll talk about it. We'll talk about strategies. But again, this is not going to happen this summer. I'm just kind of going through just the time frame. But this may not happen this summer. But guess what? You'll leave, come back, and you might be placed back on the case that you worked on. And this may happen once you're a first or second year associate, even maybe a third year associate. Okay, and with the way the timing is going right now. Okay, so I'm just giving you a thing. Practice tips, follow steps in the manual. Like I said, discuss your case with me. At the end, when you're going to send everything, you're going to send me a copy of it, okay? You will give me any drafts. You will send over to your mentor any drafts that you have made, and I will make edits, I will make suggestions, I'll make comments, and I will send it back to you. There's 2 or 3 iterations of drafts that go back and forth with me and you. Same with the forms and everything. I do try to get back to you in a timely basis. If you do have a deadline, please do not send it to me saying, my client is coming in tomorrow, can you please look at this, okay? If you have scheduled for your client to come in on Monday of the following week, get it to me by Wednesday. And you say, hey, you know what? Client's coming in on Monday. Can you please look at this? Because if you say my client's coming in tomorrow, can you please look at this? I mean, it's the summer and we have a lot of cases that we do this summer. So please be mindful of that. I don't mean to say that I won't get to it, but it gets busy. Okay. And the benefits of an approved VAWA I-360 is they can get their lawful permanent residency, they can get deferred action status, employment authorization, and they can bring their children in. And we will talk right now, we're going to talk a little bit about the adjustment of status and being able to get their green card. Yeah. Okay. Any questions on the VAWA self-petition process? That was step 1. This is step 2, right? Getting that green card. Who can get their green card right now? Okay, if your self-petitioning person's spouse is a United States citizen, they can actually file concurrently for their green card. If their self-petitioning spouse's self-petition person's spouse is a lawful permanent resident, they're a green card holder, you have to wait until the priority date is current. So this is for folks who have spouses, their husbands are U.S. citizens. Then you can file immediately for a green card. And for those of you who have that in your case file, you will file both of those concurrently, I-360 and an I-485. Okay, does that make sense? Yes, no? Yes? Can you repeat it one more time? Sure. Slowly about the second one? Sure. Okay, so if the spouse is a lawful permanent resident, they're a green card holder, you have to wait until your priority date is current. Priority date current means basically the government decides, okay, we're going to have this many immigrants in these categories every year from these countries. So there's something called a visa bulletin. You can Google it, and it's a big chart, and it says it's got Mexico, Philippines, India, China, I think, as specific countries, and then it says all other categories or all other countries. And so if you're from any of those 4 countries that I just named, your wait time is going to be longer, because that means there's so many applications from those specific countries that you have to wait a little longer. Now, the other ones, all chargeability areas, your client is going to be in something called a Family 2A category, which is a spouse of a lawful permanent resident, spouse or child of a lawful permanent resident. And you have to wait until they say, okay, we're going to be looking at applications filed on or before X date. And that's when, and if your date is, the priority date is there, then that's when you do it. The priority date is actually given in your receipt notices. You'll see samples in your manual. You'll see where it says priority date, and that's when you're going to look. And that's only if the spouse is a lawful permanent resident, not a U.S. citizen. Okay. And I kid you not, I think there's like 5 people that decide the numbers for that chart. I met the guy, one guy, and I was like, you really do it yourself? He goes, no, I've got like a crew of like 5 people. And they look at numbers and matrices and the number of people who are applying, and it's kind of crazy, but they do make this chart after looking at everything. So that is what, and if you want, you could just Google visa bulletin and it'll show up. So, any questions? Okay, so now we're going to go. Your client is now going to file the 485, okay, because her husband is a U.S. citizen, so she's able to file the 485, the adjustment of status green card application. What is it? Again, that is a change of immigration status to lawful permanent resident. It's filed on Form 485. The person has to be physically in the U.S., and it is decided not at Vermont. This is the second part. This part is decided here at the local office, 26 Federal Plaza, or out in Holtzville in Long Island, depending on where you live. Okay? And usually there is an interview. Right now, this process is taking a very, very long time. Like everything else in USCIS land, everything is backed up. So it is this process is taking a while, but this is where it goes. It's here in the local office. Okay, and it's again based on the principles marriage to a United States citizen, or their visa is currently available, so there is an available visa number for them. Okay, so how are you eligible for adjustment of status? You have an approved I-360, and you are a spouse of a U.S. citizen, or you have an immediately available visa number, and you are not inadmissible. Okay, so what does inadmissible mean? Any guesses?
It means that you cross with a fraudulent passport or cross with actually correct documentation, that particular thing.
Inadmissible. It's true. Yeah, so that is one of the grounds of inadmissibility, right? EWI, which is entry without inspection, or present without inspection or parole. That is one of the inadmissibility grounds. However, luckily for us, for VAWA self-petitioners, the manner in which they came into the country is no longer, it doesn't matter anymore, okay? That's okay. You could have come in EWI, you could have come in fraudulently, but that doesn't matter. It's okay. However, if you did come in fraudulently, you do need to waive that, okay? You have to ask for a waiver of the fraudulent entry. Okay, but the manner in which you enter does not matter, is what I'm saying. Okay, so common grounds of inadmissibility: health-related, criminal-related, due to convictions or admissions, fraud or misrepresentation to gain immigration benefit, unlawful presence, and this is triggered upon departure from the U.S., prior removal, deportation, and this is the one that most other people are going to be stuck on, is the present in U.S. without admission or parole. But as I just said, this one does not matter to VAWA self-petitioners. Re-entering U.S. without authorization, following prior immigration violations, and false claim to U.S. citizenship. These are the common grounds. You can look up INA Section 212A. all the grounds of inadmissibility are in there. We have flagged your clients for any kinds of inadmissibility that they may have. I don't believe your clients do have any, but if they do, you can waive them on Form I-601, okay? But, and we have tried to flag as many, but in the course of your interviewing and talking and a representation of your client, things may come up that they never told us. And if it does come up and you think, oh my God, this sounds kind of weird and sounds kind of something like what Esther said at the training, give me a call and we'll talk about it, okay? So maybe it is like a criminal related ground. They have multiple criminal convictions and they never told us. Okay. Any questions on common grounds of inadmissibility? Okay, so when if your client does say that they have an inadmissibility ground or presents themselves to have an inadmissibility ground, you're going to look at how you're going to look at this. It's going to be either the ground does not apply. Again, what ground does not apply to VAWA petitioners? Exactly. Present without admission or parole. Okay, that ground does not apply. So you're not going to say anything about that. And then there's VAWA specific exceptions to certain things. Okay, you can get waivers for them as well if there are no VAWA specific exceptions or general exceptions. So waivers are done on 601, and it's a discretionary determination. Most of our clients have been able to waive certain things. So for example, alien smuggling is an inadmissibility ground, okay? However, there is an exception to alien smuggling if it was for family unity purposes and you brought in one child or two children, your children, or the ones that you brought in and you smuggled them in, but there is an exception to that, okay? Alien smuggling. So you're gonna look, if you think, oh yeah, my client says XYZ, what does this mean? And we could talk about it. I'll walk you through the INA. We'll go through that if there are any inadmissibility grounds that you need to think about. What to file in a 601. Again, it's going to be, you're going to look at this. We have samples of a 601 filing in there. And again, the 601 is a waiver. And you only file a 601 if there is an inadmissibility ground and it can be waived or it needs to be waived. Okay. Travel risks for adjustment of status applicants. They may be, once you file your 485, you may be able to travel. A lot of clients say, can I go back home to my home country? They can under advanced parole. And this is Form I-131. And you could say it has to be based on humanitarian circumstances or other compelling interests. This is hard to get these days. It used to be easier, but now it's a little bit harder and it's riskier. Okay. Just because of the way the administration is and the atmosphere is around immigrants right now. So if your client really says, I really, really, really need to go back because some really, really emergent thing, yes, talk to me. We'll talk about it. We'll see if we can get them advanced parole so that they can go back, okay? The other thing is if they go back by themselves without getting advanced parole, they may trigger something called a 3 and 10-year bar. If you are in the United States and you have been here without lawful residency status, okay, for over a year, and you leave the United States, and you try to come back in, you are barred from re-entering for 10 years, okay? But that is only triggered once you leave. So people who are here and who have been here for a long time, who have never left, okay, they don't trigger that, okay? But it's only triggered once you leave. So there are clients that have said, oh yeah, I was here, I was on a visa, my visa expired, and I've been here like since 2009, and my visa expired in 2009. Now they've been here unlawfully for 10 years. And then they leave. And if they try to come back in, they're barred from coming back in. Okay, so this is why when your clients say, hey, can I travel, can I go somewhere, you're going to say, well, let's look at what the consequences are going to be. If you get advanced parole, that's okay. If they just leave on their own without advanced parole, that's when they're going to be triggering these bars and they cannot come back in. Okay. And so what are you going to file in the I-485, which is the adjustment of status, the G-28? If it's a concurrent filing, you're not going to do the I-360 approval, but if it isn't, then you will. But if it's like a separate filing, you'll file the I-360 approval, things like this. But you'll see this list here. Again, some things are only if necessary. You will not you do need to file a Form I-693 medical exam, but it do not include this right now. You do it later because there is an expiration date of this. They're expensive to get for your client, and USCIS is fine with you not going, not filing this at this time. So when I said earlier, like there's policies have changed to say, hey, we're going to deny you without any kind of RFE. Remember in the very beginning I said that their policies are changing and they're doing these crazy things. It's if you don't file certain things that are necessary documents. So the I-864W is a necessary document. It is an affidavit of support exemption. If you don't file this, they're saying if you don't file things like this, these kinds of forms, they may deny you. They may just deny you without giving you a chance to remedy your application. Yes.
You get denied with prejudice, or could you resubmit?
So you don't get denied with prejudice. You can resubmit. However, there's this really scary language these days because they say, well, once you're denied, they're going to issue you a notice to appear. Okay, which is crazy, within 33 days if you don't appeal it. Insane, because it doesn't make any sense. Notice to appear means that you're going to be put into deportation proceedings, okay? In the past, if an I-360 was denied, if an I-485 based on an I-360 was denied, they did nothing about it. Okay, it was just a denial, and they gave you all the time in the world to refile it or do nothing. But these days, they're saying and anytime there is an adverse decision against you from USCIS, then they are taking it upon themselves to refer you to court, and you will be referred and given a notice to appear. So this is why we want to make sure that we don't get denials, because if you do get a denial, you have to, really advocate pretty quickly and work pretty quickly to get something else filed so that you could tell them, hey, don't issue that NTA. Because once that NTA drops and your case is in court, all of this, there's a totally different ballgame that you have to play instead of this. So you definitely want to try to keep your clients out of court. Okay. Any questions? Okay. Employment authorization, that can be filed with your, yes?
You were talking about the I-693 medical exam. Were you trying to say that if you don't have that filled out, that's not one thing that would...
Exactly. Yeah, the question is the 693 medical exam form. This is one of those things they say, that's okay if you don't fill this one out yet, okay? Because USCIS understands that they have a hard expiration on this, and it's because of their policies and their backlog that we're not able to do this at that time. So they're okay with the 693 not being in there, but if any other document that needs to be in there is not in there, then that's when they're saying we will deny without a further chance of you being able to correct that record. Okay. And then we have the 765, which is employment authorization. Again, pending adjustment of status is going to be C9 category. Or if you're filing only a 360 because the husband is a lawful permanent resident, it's a checkbox saying, yes, I want an employment authorization document. Okay. What does an EAD do? It gives you a right to work lawfully. It's economic independence, social security number. It's another form of ID. You can get, you can get state and city IDs with it as well. And what to file here is same thing. You need a G28 notice of appearance. And the G28 notice of appearance goes on every single one of your forms, okay? So every single form that you have, you're going to file one of these. And the G28 is supposed to be on light blue paper, so please just make sure that you do print that out on light blue paper. After the employment authorization approval, you need to renew it because it does expire once a year or every 2 years, depending. You'll see it where the expiration date is. And you should file the renewal at least 4 months in advance, okay, because they are taking so long to adjudicate these, and they will lapse, and your client will not have an employment authorization document unless you file it pretty early on. Okay. Fee waivers. Yes.
You're talking about like this would be an iteration year after year. So when we leave for the summer, just have to make sure that for other people on our team are going to do that.
Correct.
That'll be handled by your case supervisors.
Okay, so the question was, like certain things like EAD approvals or EAD renewals have to be done year after year until you actually get your green card. And yes, that is true. And that should be handled by whoever takes on the case. You know, you're going to hand it off, and you should note it, like EAD was filed for or EAD has not been filed for because of XYZ reasons. Fee waivers. Most of these applications require a fee. The only one that does not require a fee is an I-360. The I-360 is fee exempt. The 485, the 601, the 131, the 765, all the other applications, all the other forms require a fee, and they are very, very expensive. Okay, so unless your client has thousands of dollars to file her application, and or the firm is willing to pay thousands of dollars for each of the clients, what you will do is do a fee waiver application. The fee waivers are done on form I-912. It used to be that they were very simple. You didn't even have a form. You just did an affidavit saying, my expenses are this, my income is this, I can't afford, please waive my fees. Last summer, they decided, the USCIS has decided not to be so nice and generous. And what they do is they are now requiring that everybody files a fee waiver application on form I-912. And you could do one fee waiver application for all of your forms, though. So you don't have to have a separate one for each of them. But it is an onerous process. It is a pain, actually, because your clients will need to try to prove the negative. They have to prove that they have no income. But how do they prove that they have no income? They're asking for pay stubs. Well, they're not working. Therefore, they have no income, right? And so when we are getting these rejections on these fee waivers, they're saying, well, you didn't give us enough information. Well, the only thing we could give you was our clients have a financial hardship because, and we gave a narrative. And in their rejection notices, they say, well, we see that you gave a narrative. However, we need like pay stubs, bank accounts, extra, et cetera, et cetera. Our clients don't have that. So again, you keep going in this cycle with them back and forth, like, hey, we gave what we have, but you didn't give us enough. You're trying to prove the negative. It's a real big pain in the butt. We are trying to advocate that they give us some more guidelines about what exactly needs to be put into them. But it is absolutely inconsistent in their adjudications. We've got cases where we filed exact same thing for two exact same people. I mean, it's mom and the child. Mom's was approved, child's was not, but it was the same exact information. So it's totally inconsistent. We have no idea what they're doing. I don't know if they have any idea what they're doing, but you'll see it. But again, when you do the 912 form, I'll walk you through it. We can talk about it. We can talk about what kind of evidence is needed and what kind of evidence your client has to be able to prove that. Okay, okay, so the timeline of all of this is, like I said, you should be able to do this, file everything with Vermont Service Center by the end of this summer. So month 1 to 3, you're gonna call your client, talk to your client, do all of your things, fill out the applications, have some back and forth with me, have phone calls with me, and you will file it. 2 to 3 weeks after filing, you get the receipt notice, and then it keeps going on from there. 18 to 23 months after filing is when you get your decision at this point. And then you'll see here too, same thing, okay? I'm not gonna go over the timeline. You guys can look at it a little bit more. Any questions on VAWA sub-petition and or the adjustment of status piece at all? Like questions at all on that? Okay. And again, the adjustment of status piece, all of you here probably, I mean, the latter part of all of this, you'll be looking at maybe when you come back after you've taken the bar exam and are associates here at Akin, okay? 751, so that is a self-petition process because this person never had a green card, okay? Now this process is called the battered spouse waiver process, and this is for people who have a green card. They've gone through the process. Their husband has filed for them, and they have gotten a permanent resident card. However, their permanent resident card is conditional. Why is it conditional? Because their marriage was less than 2 years old when their spouse filed for them. And this is where the marriage sham laws came in. This is why they started doing this, because a while ago, or even like more recent, even now, right? The marriage sham happens. People Get married for what? Immigration purposes. I marry Fatima and I say, hey, Fatima, like, let's get married. I will pay you $10,000. Okay? Marry me, and so I can get my green card. So she marries me. I pay her $10,000. I get my green card. And then we get divorced. We're on our merry way. It's all good. And that's what used to happen. So the government decided, okay, you know what? We need to combat this marriage sham thing that's going on. So instead of giving me, like, if we were married for less than 2 years, instead of giving me a lawful permanent residency for like a permanent one, they're giving me a conditional one. They're only giving me a 2-year conditional residency. So at the end of the 2 years, I have to go back with Fatima to say, like, hey, guess what? We're still married in a good faith marriage. We still have this good thing going on. And so please remove these conditions. Okay. And because of that, what happens in an abusive relationship? What happens this is the regular one, right? This is what would have happened. What happens if it's in they use it as another form of control, right? Same thing. Because you are reliant on your U.S. citizen husband and or lawful permanent resident husband to say, look, you know, like, can you go back with me to show that we are still married together and we're still married and we are still in a good faith marriage. So again, because of that, they decided to do, they, meaning the government, has now a battered spouse waiver. Okay. So it's a hardship waiver based on good faith marriage and physical abuse or extreme cruelty during the marriage. That is the battered spouse waiver. There's other hardship waivers as well. You have to show good faith marriage and divorce, or extreme hardship, or death of the spouse. We are going to be in that second column there, and some of your clients may fall into that third column too, because they may have gotten a divorce after they got their conditional residency. Okay. This is all filed on Form I-751. This has a fee to it, so you will need to do the fee waiver on this as well. What does it mean in terms of derivatives of conditional residence? If you have children, children cannot be derivatives. Unlike the VAWA sub-petition, they cannot be derivatives on a 751 form unless they actually received their conditional residency within 90 days of the principals. So I get my conditional lawful permanent residency. I have children, and maybe my abusive spouse, I mean, it's children from a different marriage, and my abusive spouse said, oh, you know what, I like your kids too, I'll bring them in too. And so they came in with me. They can be added onto my battered spouse waiver petition. However, maybe he did mine, and he said, well, wait on your children. Okay, we're not going to do your children until later. And maybe, I don't know, like I come in, it's been 3 months, and then he files for my kids. Okay? Then I cannot add them, include them to my petition. Does that make sense? They're not automatically added, and because it depends on when they got their status. Okay. Where do we file this? This is not filed at Vermont Service Center. It used to be, but now it is all filed at the Texas Service Center. And then Texas moves it up to Vermont. So what kinds of things are you going to show in this? It's the same kind of proof, the good faith marriage, right? So if you say for a battered spouse waiver, what's the good faith marriage piece? The photos, everything, right? But there's another piece that you can have for good faith marriage here, for joint residency, almost, if you can find it. If she has a copy, she could actually have a copy of the original filing. If she has a copy of the original filing, it could show, hey, look, there was a good faith marriage. He wanted to do this for me. Look, we lived at the same place. So you can show there might be another piece of information there. The thing here, though, is that a little bit, hang on. The thing that you need to remember is that there is already a record. So it can't be conflicting with whatever record was there. So if they filed something in that original I-130, 45 petition, and she got something, she can't say something different at this point because the record is there. And we have tried to, as much as possible, try to get that filing, the original filing, from the previous attorney if possible. If there isn't, it's okay. But again, you want to make sure that whatever the client is saying now coincides with what she said then about marriage date, how they met, all that other stuff. Again, this is the same kind of the proofs. You're going to have the same affidavits of the good faith marriage. The only thing you don't have to have in the as proof in that's not an element of the battered spouse waiver petition is you do not need good moral character. Okay, there is no good moral character requirement for a battered spouse waiver. So in some ways, it's a little bit easier, but it's going to be this. You're going to get the same kind of evidence that you need. Okay. Again, you want to use updated forms here. Actions after USCIS, and what USCIS will do is you'll get a receipt notice, and it will extend the conditional residence. Okay, your client already has a green card. So as long as this is filed before that green card expires, that she will get an extension notice saying that her green card is, or her green card status, or her lawful permanent residency is extended for 1 more year. What does that mean? That means she can take that piece of paper and travel. She can go outside the country. It's fine. Okay. And while everything is pending, you know, she can travel and she has her green card status. It's okay. She can, you know, work and all of that. She does not need an like a different employment authorization document or anything like this. They may give you an RFE. They may give you a NOID. They may interview. Okay. In the past, on 751s, we did not get interviewed. Now, increasingly, we do get interviewed after they adjudicate everything. These are also taking over a year to adjudicate. So once you file this, you will probably not hear anything until you guys are back here as associates. Okay. The timeline, again, here we go. Months 1 to 3, you'll do everything. You can file it by then. There's going to be biometrics. Biometrics is a fancy word for fingerprinting, and you just you go with the client, and you can go with the client. The client could go by himself. A lot of times, clients want you to come with them because they're a little scared because it is a government office. I have yet to hear of anybody being picked up by ICE or detained while they are doing a biometrics fingerprint appointment. And so basically, it's fingerprints and a facial scan. And then after that, you will either get an RFE or a decision, and it's just like a waiting game right now. It's 15 to 20 months after filing at this point when they give you a decision. Here's some best practices. Again, communicating with USCIS. You're going to check processing times, and this is all on USCIS.gov's website. Sign up for case updates. This is a good thing. Once you get that, and this is mostly for the managing attorneys that are actually, or the supervising attorneys after your summers have filed this. Once you get that receipt notice, you will have a receipt number. It starts with EAC usually, okay, or MSC. You're going to take that receipt number and you're going to sign up for case updates on USCIS.gov. You're going to make a profile and sign up for this so that anytime there is any movement on your case, you will get an email notification saying, we have mailed a notice to you on XX date. And so then you could actually alert your mailroom to be on the lookout for something. Or if you never get it, then you could like kind of start bugging USCIS to say, hey, look, we never got our notice. Yes.
As I know to the supervising attorneys in the room, Lauren Connell tracks all of these, so just make sure to give your receipt notice number to Lauren Connell, and she'll put it in the firm tracking system.
There you go. Okay, so Akin has it done in a one place, compiled place. So talk to Lauren about it once you get your receipt numbers. Again, send all applications to USCIS through trackable mail. Please don't use USPS. I really discourage people from using USPS. They are not as cheap as you think they are, and they are not reliable. So use FedEx, UPS, something else. Alert your mailroom of expected mail from USCIS. Make sure that you do talk to Lauren, you do talk to your mailroom. Sometimes we get clients' mail in, and the thing is, they won't say the attorney's name. It will say the client's name. And maybe Olivia Martinez does not work at Akin, obviously, because she's a client. So, and they don't know that. And then the mailroom like forwards it to somebody, and then the man, like I've had this happen at a firm. Actually, this happened to the same client twice, where it ended up in the managing attorney's office and they said, well, we don't know who this person is, and they sent it back to USCIS. And it was her work authorization, and this happened twice. So just make sure that you do keep track of the clients and let the mailroom know, or let Laura know, or let your pro bono counsel's office know, hey, this is a pro bono case. How are we supposed to track this when the mail comes in? Because the mail is not going to come in your name. It will come in the client's name. Emailing or communicating with USCIS, you can email them. These are the two different email addresses. If you have a battered spouse waiver or if you have a self-petition, you can call them. And if you do, I mean, you guys won't have this need right now. We contact them if they're outside of case processing. We contact them if there's something wonky going on with the case. They've given you an RFE, or they've made an adverse decision that you think is wrong. That's when we start contacting them. And the National Customer Service Line, they are asking that everybody use this for any kind of case inquiry these days. And especially your clients who have the battered spouse waivers, if it expires, they can get a stamp in their passport to show that they are still a lawful permanent resident, and they can get a conditional residence stamp. And in order to get this, you have to call this National Customer Service Line. They call it the contact center now. You have to go through this whole system to say, I need an appointment at the local office to get a stamp. And it has, people have been successful in doing that. But again, that's later on. Nobody here probably will need to do that. Communicating with me or your mentors, you're going to send us all drafts of all forms, affidavits, cover letters, index of evidence. I will ask you for things if I think things are missing. You don't have to send it to me when everything is ready. You can send it to me piecemeal. Okay, say that you have the client's affidavit ready, you can send it to me. If you have if you have supporting affiants, you can send that to me as well. But again, you can send it to me piecemeal. It does not have to be all together. I'm going to read a code, one more code. It's 424XY, 424XY. Expect me to comment and send it back to you. It's not because you're a bad writer. I know that you guys are here. That means you're excellent students, excellent writers, excellent attorneys. It's just that I kind of have been doing this for a very long time, and I know what they're looking for. So I will, ask you more questions and say, hey, what about this? What about that? Can you get more information here? Please do not be offended. It's just that we just need more information. Okay. Send PDF copies of all filings to me afterwards. After you're done, you're going to PDF it, send it to me. I do not need a hard copy, but make sure you keep a hard copy for yourself. You make a hard copy for your client, and then you send out originals to the USCIS. Okay. Again, contact me or your mentor after you review the training, annual, and case file. I think all of you have done the case file. Hopefully, you can call me before your first meeting. You can call me after your first meeting. Sometimes I like to have a call before your first meeting to talk about the case, to say, okay, these are the things you want to kind of talk to her about. These are the issues we see. And then after your your first meeting, you want to call and say, okay, these are the things, like it was a good meeting, it was a bad meeting, she's not talking to us at all, we can't get in touch with her, whatever it is, give me a call. Okay. RFEs, noise, all that stuff is going to be later, so it's okay. And when you have to communicate with your client. You have to keep in constant contact with your client. The adjudication times are very, very long these days. They are going from, over a year now. So in that time, things will happen to your client. So make sure that you do contact her every 6 months after the filing. Just say, hey, anything new happened? Did you get arrested? Don't ask her, did you get arrested? But just say anything new happened. You want to update us on anything? Did you move? Are you still living at such and such address? Is your phone number, is this the best way to contact you? Do you have an email address or what have you, right? So talk to your clients because things happen. Your clients' lives keep moving forward as USCIS is keeping their applications, in this holding pattern. So a lot of clients do move. They move out of state. And what does that mean? It doesn't really mean much of anything as long as, they are willing to come back in to talk to you guys, or they're willing to come back to do the interview. Or if the client says, you know what, I've moved, I would like other counsel in my state now, then we can always try to transfer them to other places, okay? So just make sure that you do have a tickler on your, this is more for the managing or the Supervising attorneys, make sure you have a tickler on your calendar just to contact this person every 6 months. Okay. And anytime you get any kind of USCIS notification, you're going to call the client and say, this came in. Here, let's talk about this. This is what this means. Okay. Anything else on this? Nope. Okay. Online resources, again, all forms, uscis.gov. Checking status. Everything you can see, you need is on uscis.gov, really. This InfoPass thing, ignore it. I forgot to take it out. They have gotten rid of InfoPass. You will do it all through that contact center phone number that I sent earlier. If you need to see that visa bulletin, this is where you're going to find it. But if you just Google visa bulletin, it will show up. Offline resources, again, you guys have your manual. It's 600 plus pages long. It has extensive samples, extensive. We do not need you guys to reinvent the wheel, really. But remember, these are samples, so tweak it, use it, but make sure it is for your client. These samples, our client's name is Hannah C. Client, okay? I've gotten affidavit drafts from folks saying, Hannah C. Client, blah, 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 and they didn't bother to change that. Please make sure you change that, okay? Things like this. And anything else? No. And this is her justice mentors on this for immigration. There's Tim, me, Susanna, and Amanda. So whichever firm you are with, you will have a mentor assigned to you. Again, Akin is with me, Cravath is with Susanna, and then anybody else you'll know in your case opening reports. Any questions at all? I know it was very long, a lot of information. It will start to sink in once you start to talk to your client, and hopefully, and you can always reach out to us. I do come back once in the summer for a Q&A, and we'll talk about when that is. It's midsummer, so you'll have been in your cases for a while. You'll have at least met your clients and started the affidavits, and this is when we start troubleshooting like other issues that have come up, okay? So again, but I am available through email and through phone whenever you guys need. Okay. So thank you so much for hanging in there and being good participants.